The title of today's Brandon's blog is Suspension of Discharge from Bankruptcy, our complete guide on bankruptcy discharges. On September 29 of this year, the Court of King's Bench of Alberta, it's going to take us a little while to get used to that, now that there's a king and no longer a queen. And this case dealt with a bankrupt's application for discharge. And there was nothing very complicated about it, but Brandon thought that it really, in a simple way, epitomizes the balance and the fairness the court strives for in balancing the rights and responsibilities of the bankrupt, the right of the bankrupt to ultimately receive a discharge from bankruptcy, with the rights and expectations of the creditors from the Canadian bankruptcy process. My name is Ira Smith, president of Ira Smith Trustee and Receiver, Inc. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you. I hope you can watch until the end of this video, because I know you will find it informative. In this blog, Brandon first discusses what a bankruptcy discharge is and what it means for the bankrupt person. Next, he goes on to discuss when can a bankrupt person be discharged. And it depends whether it's their first time bankruptcy or second or third time bankruptcy, and whether or not they have a surplus income requirement to make payment to the bankruptcy estate. And Brandon goes through all those permutations and combinations below. Then he discusses what happens when a bankrupt's application for discharge is challenged, either by the trustee or by one or more creditors. And why would a trustee or a creditor challenge the bankrupt's application for discharge? Next, Brandon goes through the different types of bankruptcy discharges, be it an automatic, an absolute, a conditional, a suspension, or a refusal. Brandon goes through all of those different types and explains what they mean. Brandon then discusses the 5 types of debt that are not dischargeable in anyone's personal bankruptcy, and he lists them down below. He then gets into the case and describes the case of a woman who went bankrupt after 10 years of litigation that she started against her siblings, trying to overturn her father's will and get a larger share of the deceased estate. She racked up huge legal fees and also had cost awards against her because she lost every step of the way in the litigation. The court looked at the evidence before it. The trustee reported that there were several issues of conduct to be concerned about with this bankrupt. There was the racking up of all the legal fees. There was the fact that she allowed a charge to go on against her half interest in the matrimonial home, supposedly a loan from her husband for legal fees. And third, 13 months before she filed for bankruptcy, she transferred her interest in the house to her husband. And the trustee reported on all this. The court looked at all this and said, We highly doubt all those loans were made to her because she has all these outstanding legal fees. Secondly, although the transfer of the house under one statute was outside of the automatic period the trustee can go and attack that transaction, there were other possible avenues of attack, but there were no funds in the estate to launch that attack. And the creditors also stated as a reason for opposition that this bankrupt could have tried to make a proposal, but didn't. And the court agreed with that. So looking it all over and trying to find fairness, equity, and balance, the court essentially calculated what her net equity in the matrimonial home was at the time of the transfer, and looked at her income and made a conditional order, the condition being that she's going to have to pay $2,000 a month on top of what she already paid in surplus income, so that there would be a total pot of $120,000, which roughly equaled what her equity was in the half interest in the matrimonial home. And so the court ended up requiring her to make the payments she would have made in what could have been a successful proposal. And she is not entitled to her bankruptcy discharge until she makes all those payments to the trustee for the benefit of the creditors. So I hope you can read the entire Brandon's blog below, because I know you will get value from it. Again, both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you.